and welcome to our YouTube channel. Thank you so dearly for always supporting us. I really do appreciate. If today the first time you are coming across this wonderful family, or you are seeing my face for the first time, I still remain AGATHA Progress, bringing it to you back to back. Remember, we react to all videos and all opinion is highly needed. So just sit back and watch this video and I will be right back.
Of law. I'm not one of those lawyers that may go and meet a judge like Nicodemus at night to say, help me. I fight my own in court frontally. This case is bad, bad, bad. Once you don't agree, I say, take to another lawyer. I'm not going to have blood money on my hands to take on a case that I know is bad, is dead on arrival. So, because no country can survive without the rule of law. It's just not possible. It is our ability to subsume ourselves to the operation of rule of law that makes us different from animals, that removes us from the Hobbesian state of nature, where life was short, nasty, and brutish. By 1885, Professor A.V. Dicey had already discussed the concept of rule of law, which, in summary, is subjection of all persons before the law and equality before the law. Whether you be a sovereign, president, head of state, or the Franz Fanon's wretched of the earth or the hoi polloi, you must be one and the same before the law. Before the law, nobles and commoners, slaves and slave masters. Once you begin to distinguish as between categories of people, then there's going to be trouble and anarchy. That was why last year the president missed it when he said national interest, in quote, should be subordinated to rule of law. That was wrong. Because national interest is defined by every government according to its own blood binoculars, which is normally government interest, not national interest. But the rule of law itself predates man. It started from the Garden of Eden. It was the violation of the rule of law in the Garden of Eden that got God angry with Adam and Eve. And he decided to drive them away because he laid down some rules. Thou shalt eat of all this fruit, but of that singular forbidden fruit thou must not taste. It is a violation of that rule of law in the Garden of Eden that God got angry and he had to drive it them. So making the rule of law central is very important. And the president of IBA was here to look at some of these issues. And many distinguished panels actually looked at many of these issues very critically. And I think it was a way of driving it home to the present government that you cannot operate outside the rule of law. No matter what anti-corruption you say you want to do, no matter how you say you want to go after supposed enemies of state, you must first and foremost go within our constitutional and legal organogram and regime. Anything outside it then becomes anarchical and it's unacceptable in any constitutional democracy, Nigeria inclusive.
But was that point driven home? I mean, I take you back to what you just said about how the president made that statement about how the national interest supersedes the rule of law. He said that in justification of certain actions of the executive, but also as a foreshadowing for what was to come, which was the rather scandalous removal of the Chief Justice of Nigeria, Walter Onnoghen, and his replacement by the current CJN, Tanko Mohammed. The Senate Minority Leader raised that point and was quite critical of the NBA and their stance in that matter, or failure to take a stance. And he got rapturous applause as a result of that statement. You buttressed that point. You raised the Pakistani precedents where the lawyers took to the streets because of Musharraf's removal of Chowdhury.
Yes.
But you were contradicted by Femi Falana SAN, who made a statement along the lines of the person's morals, that it's difficult to don a cape. I'm paraphrasing. I'm not quoting. It's difficult to don a cape for somebody whose morals are not quite up to par.
I don't like discussing people, particularly when they are not there. But because we mentioned Femi Falana specifically, let me say he was dead wrong. He said that Mohammed Chowdhury, the then Chief Justice of Pakistan, was not accused of corruption. That is not quite correct. President Pervez Musharraf accused him of misconduct and abuse of office. I do not know what greater elements constitute corruption than abuse of office and misconduct. Femi Falana may have been defining corruption from the narrow perspective of this government that I've seen in the last 1.5 years. They think that corruption simply means the giving and taking of bribery. They do not seem to realize that political corruption prebendalism, cronyism, favoritism, nepotism. They are all the isms. They are even greater forms of corruption. Now, on the 9th of March, 2007, Pakistani lawyers poured on the streets when the then president, Pervez Musharraf, removed the then Chief Justice of Pakistan, Mohammed Chaudhry, accusing him of gross misconduct and other criminal acts. And the lawyer said, no, you cannot do that without first subjecting him to a proper trial. And they poured onto the streets. For months and months, they literally shut down Pakistan. In fact, they had to force the government and the judiciary to bring back the Chief Justice. Even if you say Onoge was corrupt, quickly, this moment as I'm talking to you, no court of law has tried Onoge to find him guilty of any crime. Even the Code of Conduct Tribunal, they removed him preemptorily with an ex parte order. Even when the proceedings were still going on and his jurisdiction had been tried, the Court of Appeal, in the case of Justice Onogo versus the CCT and others, actually held that the Code of Conduct Tribunal was wrong to have ordered Onoge to be removed. So even as we speak, Onoge has never been tried nor convicted of any offense. They forced him out. All they wanted was to force him out of office. And that they have successfully done. Otherwise, why would the Court of Appeal wait for nearly 3 months before delivering judgment in such a simple matter that they could have delivered judgment from the following? By the time they delivered judgment, almost 3 months later, it was too late.
But what are our chances?
So my argument is that even if Onoge were accused of corruption, what we are saying is that you must allow him to pass through the due process of law before you can remove him. And the Constitution is clear. Sections 153, 158, 291, 292.3, Pass A and B, Section 21 of the 3rd Schedule, they are all clear that before you can remove a judicial officer, you must subject him to trial by the National Judicial Council. And that was why the Court of Appeal heard in Erelu Habib, the Supreme Court, as a matter of fact, in Erelu Habib's case, and the Court of Appeal in Ngajiwa's case, that you cannot begin to try a judicial officer until he has first been disciplined by the NJC, which is independent in accordance with the doctrine of separation of powers, ably propounded by great philosophers like John Locke, John Calvin, Immanuel Kant, and most ably propounded in 1748 by Baron de Montesquieu, that the 3 arms of government must be distinct, different from each other, so that there will be checks and balances.
Yes, well, sir, you have cited, I have to follow up. You just cited constitutional procedure, Supreme Court precedents. All of these things should be inviolable. What are our chances as a democracy if people within the legal profession do not seem to grasp these simple concepts, that the ends do not justify the means? Oh,
what we are seeing, it's not that they do not know. They know. It's just that they want to sidetrack the law Nicodemously. It's an assault on the rule of law, which was where we started from. It's an assault on the rule of law. It means we are not ready to subject ourselves to principles of good governance and rule of law. Once you subject yourself to rule of law, then you will see that even if you were going to remove Onoge, you could still allow the judicial process take its place. But what many of these people believe is what you call mob lynching. Oh, you have accused him of corruption. In fact, the government, their spokesperson, like Mohammed, say, oh, name and shame them. But when they have problems, they get run back to the same judiciary that they had denigrated.
A short break.
He's a great man, and no matter what they do to buy his conscience, it will never work because he stands for the truth. He is His Excellency Nnamdi Kanu'S lawyer. He's among the legal team. So in case you don't know him, he's Michael, and he has been doing a great job. He is well known, and he represents his personality by acting according to the law. So therefore, DSS should shine their bribing status to someone else. He is not interested. My word, that brings us to the end of this beautiful update. Do well to like this video, share and subscribe. The best thing for you to do is to join this family by smashing on that red subscribe button that says subscribe and turn on the bell icon for more latest updates. See you when I see you. From me to you, I say bye.